Hello and good morning, friends. Welcome to the CEC-UGC live lecture. Dear friends, with another lecture on gender studies. In this series, we have conducted numerous sessions. Today, we would be talking on gender and law. Dear friends, for this very discussion, we have once again with us in our studios Dr. Archana Prasad. Dr. Archana Prasad is Assistant Professor in Department of Sociology, Kamala Nehru College, University of Delhi. So, dear friends, let's welcome our guest, Dr. Archana Prasad, and let's try to understand more and more about gender and law. Hello, ma'am. Welcome to the UGC lecture.
Thank you, Gitika. Welcome to the series on gender studies. Today is the 10th lecture on gender and law. Law as an institution is as a part of social society in itself is double-edged, because if you don't utilize the existing legislation in the right direction, then it might lead to more problems. And it is more important because law has two stages. One is the formulation of the law and two is the implementation. And the implementation gets problematic because most of the time it gets implemented at the intersection of caste, community, and when it comes to gender, it becomes more problematic. Because for a very long time in the history of legal institutions, lawmaking, we see that for a very long time, law in itself was a male perspective, in the sense that it was made by men, it was made for men, and it was implemented by men itself. So it was at very later stage towards 19th century where women's movement played a significant part in bringing in legislations which would directly affect women and would benefit her in terms of gaining empowerment and women's rights. But the other side of this story is that gender becomes significant because it's not only about women. So today in the 21st century, we see that there are large number of laws which have been misused or which has been targeted by a large number of population as being benefiting only to the women section. And that is where men are considering the demand for gender neutrality. Therefore, gender law should be such that it does not differentiate between one gender over the other. And that makes it very significant to understand that large number of laws in India which are made from the perspective of women have not been implemented in the right direction. And that is, we'll see in the course of the lecture that they have been patriarchal mindset, patriarchal attitudes which has colored judgments. And therefore, to actually consider law as a medium of bringing about empowerment is still continues to be a long struggle. To come down, today's objective of the lecture is to explore and analyze law as a gendering practice. Gendering in the sense is to assume that law is a practice that interacts with other practices to produce meanings about gender. And this is one of the most important tasks of feminist sociology, to bring about the analysis of law with reference to the gender meaning. To demonstrate how legal discourse participates in the defining and construction of women and thereby reproduces the social relation of power that we find in contemporary law. To understand how legal struggle over meaning about genders are reproduced, legitimized and refashioned. And that is the most significant objective. Right from the making of the law to its implementations to redrafting and amendments, we see that the entire meaning of gender keeps changing. And that becomes very significant to understand crimes like rape and dowry, where the entire meaning of gender has changed. And that is the greater part of contribution has been made by the women's movement in terms of understanding how the meaning of gender is constructed and reconstructed through legal institutions. And therefore, law becomes a site of struggle. And that is again looking into the discourses on the history of the feminist movement. We see that the feminist movement utilized it as a site of struggle, right from the campaign against dowry to amendments in the rape law to amendments in marriage and property laws. It has seen that it becomes a site of struggle to bring about an end to the system of inequality which is existing in the society. So today the lecture consists of two parts. In the first part, we try to understand the basic understanding of gender and law, to try to understand the intersection of gender and law, and in that we'll try to see how the legal history has been gendered. We try to question the mainstream assumptions in legal scholarship, and that is the role of the feminist jurisprudence or the feminist legal theory, which has become a significant part of academic work, where a large number of feminists are contributing to analyze law as a means to bring about gender inequality. And therefore, we try to understand what is the status of women in terms of the law and legislations. And in spite of the entire effort by the feminist and the women's movement, we see that there is still a large amount of work that needs to be done in terms of making representations of women in the legal system a reality. Even now, the ratio of men versus women is problematic. For example, in the Indian system, if we see, we try to understand that even the number of judges at the level of Supreme Court and High Court are completely less compared to men, and therefore it is not necessarily that women judges might pass gender sensitive judgment, but the number does make a significance, and therefore we try to understand why are laws ineffective. There are a large number of factors which has contributed for the non-functioning of gender laws across the world. And therefore, we also try to understand the demand of today, that is gender neutral laws. Trying to understand the whole understanding of the relation between gender and law, we try to see what is the contribution of law to gender equality. And here we try to see that law helps to reflect, reinforce, or challenge gender-based discrimination. And right from the drafting of the constitutions to the framing of laws and to the implementation, law has been a constant medium for struggle against inequality, and therefore can be seen as a means of changing gender relation. Women have been used law as vehicle to obtain societal and personal changes. There's a number of examples where we see that law has been used by the society a large number of times where we bring about change in the society. Law technically confers equal status to men, that is, all constitutions across the world recognizes equality of men and women legally. But what becomes problematic is in terms of it becoming a reality in society, and that is, though the rights are guaranteed, it does not get implemented. And because of the reason is that it is the patriarchy or the patriarchal mindset which prevents from making law as an instrument of change. Women as justice users have limited capabilities to access justice due to a variety of barriers, and that becomes problematic because law cannot be seen just in a vacuum or abstract from other reality. Law is related to other aspects, that is economy, the polity, and the cultural context. And in the Indian context, it becomes very significant to see that most of the time gender law are affected by community law, by custom law, by religion, by politics, and that becomes very problematic in terms of guaranteeing the legal status to women as equal citizens of the country. When we try to look into gendering of legal history, we try to grow across through the 3 centuries. If we look into the 19th centuries, most of the law was in the term of an Anglo-Saxon white men created law, and that is why it was considered as a barrier to women. Most of the law did not recognize the existence of women, and therefore there was not denial of women to education. There was a whole understanding in the law where women were dependent on men, and laws were drafted in a manner in such that women was considered as a dependent member of society, and therefore did not have an independent identity as such. As a result, the laws which were drafted in the late 19th century had a kind of a denial from education, denial from access to, if you look into the Hindu Succession Act, but they did not give right to women to have access to property. 19th century, late 19th century, law became a weapon, and that is why even in the social reform movement, large number of reformers used law as a means to bring about change. So there were anti-sati law, there were anti-dowry law, there was a widow remarriage act. So large number of legislations came in, but if in the context of India, it again becomes problematic because these were all laws which had a British colonial history. In the 21st century that we see, a law has been a very significant instrument in bringing about change, and that is activists in the legal arena have changed law to embody gender. But law's male bias remain pervasive enough to make legal doctrine more responsive to men's claim than to women. Assumptions of mainstream legal scholarship. Law is relatively autonomous, social practice discrete from politics, ethics, and religion. And this is an understanding within the legal scholarship that law is completely autonomous, that is, it is independent of the other realities of society, which is very problematic because it has to be tried to see the access to justice system itself is colored by politics, caste, and creed. So therefore, the feminist theory seeks to reveal the ways in which law reflects, reproduces, expresses, constructs, and reinforces power relations along sexually patterned lines. In doing so, it questions law's claim to autonomy and represents it as a practice which continues with deeper social, political, and economic forces which constantly seep through its supposed boundaries. And to make it more simplified is that the feminist understanding is to see it as a reality, and to see it as a reality where law is a kind of at the center of the social, political, economic relation, and the effect of law is equally felt on all these institutions, and these relations equally impact law. The language of law have almost exclusively been men, white, educated, economically privileged men. And this to a large extent has not changed, where we see that law becomes beneficial only to who have access to the justice system, and that is those who are economically well off in the society, those who are aware of the legal legislations, and therefore in the larger context, the annual beneficiary actually are left out. And therefore, you need to understand that law need not necessarily be considered as an instrument which is for the rich and for the upper caste. It should be used as such that a larger population is able to use law as a means to access justice. And as I have already said, it is the history of law says that in the initial formulation part, it was the men who have shaped it. It was their perspective that went on into the divining what is law, what is the understanding of law, how law can be used to benefit the society, and therefore we can say that there was a kind of a male bias in the entire formulation of the laws. McKinnon is one of the feminist writers who have extensively tried to see the relation between law and gender inequalities. He views law as a mode of constructing knowledge which claims objectivity. Objectivity means that it is not going to take into account the subjective stand of the individual, but when it gets implemented, we see that law becomes very subjective, and most of the time the subjectivity is the subjectivity of the men. Law is patriarchal, no doubt, because the entire formulation and implementation has been done to a large extent by men. But it does not mean that it has not contributed to women at all. It has addressed the women's cause. There are n number of legislations which are directed for the empowerment of the women, for women to take access to the justice system and to consider women as equal citizen. But again, keeping in mind that it is a patriarchal system in which it functions, its effect or its outcome becomes quite negligible in relation to its achieved goals. It's men's understanding of women, women's nature, women's capacity, and women's experience, and that is, women are seen as refraction from the male eye. So the whole problematizing of the problem is of a crime is problematic, and therefore there was a need for amendment of large number of laws from a feminist perspective. We will see how most of the laws related to gender or dowry in the initial stages of the time, and most of them were formulated during the British colonial rule, were a kind of a reflection of white men understanding of women's problem, and they all were amended in order to bring about the genuineness of women's problem in the context of specific society. Because you cannot have a law which is culturally or universally applicable to women of different caste, women of different religion, different political stand, and that necessarily needs law to be amended. Many doctrinal areas of the law are also fundamentally structured around men's perspective and experiences, and the most important example is the field of labor law. Uses a gendered meaning of work, that is which is done for wages outside your home as its focus. To recall from the lecture on economy and women, we saw that most of the understanding of who a worker is again male-based, and therefore the labor laws which were all made with the perspective of considering men as worker, and for a very long time it was the women who were out. If we bring back the example of the Indian administrative services, in the initial stages, the women were not supposed to be married to get into the Indian foreign services. A case was filed by one of the initial women who had to take permission from the government to get married. These legislation has certainly changed, but what is important is to see is the time in which it was framed and what is the context under which these laws were framed. And coming back to women and work, we see even today for a very long, the whole understanding in the society is that worker is a man who is earning his daily bread, and therefore the income of the women is secondary, the work of the women is secondary. This results in large number of gender inequality in terms of differential wage and in terms of differential treatment to women in the economy. Coming back to feminist jurisprudence. Feminist jurisprudence is a branch within the legal feminist theory which is based on the belief that law has been fundamental in women's historical subordination. And that is, when trying to understand the root cause of female subordination, one needs to understand that where is the problem, and one of the identifiers is obviously law. It has two objectives. One is to seek to explain ways in which the law played a role in women's former subordinate status. As I have already said, that the whole understanding of law was to see women as dependent members, and therefore the moment you see it as a dependent members implies that women are at a subordinate status. The second objective of feminist jurisprudence is that it aims at changing women's status through reworking of law and its approaches to gender. The feminist jurisprudence has two branches. One is the reformist or the radical. As the name suggests, reformist means to bring about reform in the law, to change the laws, existing laws, so that it becomes more gendered and becomes more as an access to acquire gender justice. Whereas the second branch is sameness and difference. That is, some of the time they say that the law needs to be changed. It is necessarily to whether you want to treat men and women as same or as equal. And it is, if you consider men and women as same, then the laws should be equally applicable to both the gender, but if it is considered as a question of difference, obviously different laws are required, and both the branches try to put across their own understanding and their own arguments to support the understanding of legal jurisprudence. When we look into the feminist legal theory, it has contributed to a large extent to the understanding of linkage between gender and law, and therefore it has contributed to understanding of gender as a constructionist perspective. In the very first lecture on understanding gender, it was argued that you need to have a social constructionist perspective. That implies that gender is constructed in everyday life. You attach a meaning to gender on the basis of social interaction. So the legal feminist theory also tries to see it as a form of a social construction where meanings are attached, where meanings changes, and the understanding of gender is very contextual. And in that implies that gender relations are subject to revision. You cannot have a unitary kind of an understanding of what is gender. Again, gender will depend on the social, economic, political context in which the law is implemented. Again, we go back to the whole idea of legal feminists having two branches. One is the liberal feminist and the other is the difference feminism. Liberal feminists are committed to the ideas of gender neutrality and equality before the law. Its focus is primarily instrumental, seeing law as a tool of feminist strategy and the impact of law as the basis for feminist critique. Difference feminism is skeptical about the possibility of neutrality. It has implicit commitment to a more complex idea of equality, which accommodates and values whilst not fixing women's specificity as women. Difference feminism has a focus on the symbolic and dynamic aspects of law and not just on its instrumental aspects. Now, when we try to understand women's legal status, we have to understand in the relation of three different kinds of law. One is the international law, the second is the domestic law, and the third is the customary law. International law, we see women are protected by international human rights treaties, particularly the Convention of Elimination of All Forms of Discrimination Against Women. It is commonly known as CEDAW. It has a large number of principles of non-discrimination on the basis of sex, on the basis of affirmative action, and it contains special provision for the protection of rural women for the lower caste women, and it is a large global weapon for bringing about change in the legal status of women. Then we have the domestic law. Domestic laws are national legal systems, and each country has its set of laws which are implemented at the level of the nation, which has trying to understand women as equal citizen of the country. Then we have the customary law. Customary law is a body of rules founding its legitimacy in tradition. That is, each community and having a different culture, having a different tradition, has its own law. If you see in the context of India, we see the Hindus have their own laws of Hindu Marriage Act and the Muslims, and therefore each customary law protects the tradition and culture of the community as such. When we try to see women's legal status, what is problematic is that it gets intertwined at the level of international identity, at the level of national identity, and at the level of community identity. Many a time, women have to sacrifice their legal status for the welfare of the larger community, which is the international, at the level of international, national, and community, and therefore it becomes problematic in actually implementing laws in a gender justice manner. If we try to under gender equality and legal pluralism is a context in which laws are applicable at different level, and that is what is at the level of nation, at the level of community. It is a system in which society recognizes more than one source of law. So you have the international source, you have the national and the community source. What problematic is that different legal institutions and underlying norm coexist, reinforcing, contradicting, complementing each other. In such society, everyday transactions such as marriage, inheritance, and land exchange falls into the jurisdiction. Gender relations sit squarely at the intersection of these different, often contending normative orders. A country may be signatory to an international agreement on non-discrimination against women. At the same time, it confers authority on customary legal system to resolve inheritance dispute, and therefore gender law becomes a little problematic. Discrimination against women emerges not solely from any one of the different systems, but rather from the combination. Discriminatory laws in the area of family and marriage can affect men and women differently. We try to see the representation in the legal system. We've seen that we have already argued that the representation is comparatively problematic because it is not as equal as we have of the men, and therefore it is to understand why is this a problematic, why are not more women represented in the legal and the judiciary. And it's not only a problem of one society, but more or less almost all society. Women lawyers are underrepresented in judgments, say full partnership in legal firm, law school faculty. We have a kind of a sexism operating in the legal field where it is a kind of understanding where law is considered as favoring one sex over the other, and that actually affects women's representation in the legal system. Most of the educational system is also suffering from, most of the time it is considered as a male profession, and therefore the number of women in these law schools or in the judiciary academy is comparatively less compared to the boys. Then we have an ineffective justice structure. Gender bias and lack of sensitivity. The justice mechanism may be gender biased or lack gender sensitivity. For example, there are still prevailing beliefs within the justice institution that domestic violence and marital rape are private matters and not properly within their jurisdiction. Large number of time, family and marriage law jurisdiction takes on the patriarchal understanding in terms of the judgment. Then there is a limited capacity even where judges, magistrate, justice personnel are not biased and understand gender issue, they may not have the skill or the institutional capacity to address gender inequalities. And therefore the civil society has played a role in terms of gender sensitizing these legal judges and the lawyers. Why are laws ineffective? Because they focus on stringent punishment. Stringent punishment deters conviction. Strict laws give more power to police, tardy investigation, forensic evidence. Onus of the proof is on accused. The entire legal system is patriarchal, law making to law enforcement. Large number of factors are actually playing in terms of the implementation of gender laws, and therefore it's not as successful as it has been envisioned by those who were formulating laws or those who have called in for gender reforms. Now, there is a demand for a gender-neutral law. In rape law, sexual harassment laws, there is a large number of understanding that women are at a better advantage and the men are victimized. A large number of cases have been used by women in terms of victimizing men, and therefore there is a demand for gender-neutral. That is, it should not only where the women should be seen as a victim, but it should be the men who could also become victimized. But the understanding is that the implementation of law is so patriarchal that it is very problematic for even a gender neutral law to function effectively in society. And it is important to understand that law does not operate as a unitary in terms of autonomy, but it is integrated in terms of the other institution, and this will offer a holistic understanding of the legal system. And to make it more effective and to make it more gendered, it is important to let it function in a setup which does not get affected or colored by the patriarchal structures of the society. This we come to an end of part 1 of today's lecture. Welcome to the second part, in which we try to understand the understanding of gender law with specific focus on the Indian society. It is very important to understand the Indian society in a different perspective because the structure, the culture and the economy polity is different from what it could be in the Western context or what it could be in the time of the laws which were framed under colonial rule, and therefore it has to be understood in the context in which women are having access to gender and law. If we look into the content of part 2, we see we'll begin with the constitutional safeguard, that is how has constitutional guaranteed equality to women. A large number of provisions in the constitution guarantee women a protective measure. Then we look into laws under the IPC, which it would covers law related to marriage, property, dowry, prohibition and domestic violence. It has achieved, if we traverse through the history of gender and law in India, it has achieved a large number of milestones. There have been very gender positive neutrals given by large number of judgments, and it has led to the promotion and equal treatment of women in society. And this has been possible because of the legal campaign, which is again a part of the Indian women's movement. We look into the landmark judgments which has brought about change in the structure of gender relation in our society, but the most problematic part is that there's still a bias, there's still a male bias. Let's just look into few of the cases where the judgment given by the Supreme Court has been biased towards women. The entire understanding of patriarchy gets reflected in the judgment given by these Supreme Court and High Court judges. And therefore, it is important to understand that what are the obstacles that has prevented and it is a long struggle for India to actually use gender sensitive law for empowerment. If we look into the constitutional safeguard guaranteed by the Constitution, Article 14 says that the government shall not deny to any person equality before law or the equal protection of the law. This is a directive for the understanding of equality of gender. Article 15 declares that the government shall not discriminate against any citizen on the ground of sex. And the moment these articles are not implemented, there have been a large number of PILs and there have been large number of cases which has been filed again, and the court has come in protection of women and ensured that these articles are granted to women across the country. Article 16 guarantees that no citizen shall be discriminated against in matters of public employment on the ground of sex, religion, caste, creed, descent, place of birth and residence. Article 21 of the Constitution gives protection of life and personal liberty of the individual. Article 23 prohibits trafficking in human beings and forced labor. Article 23 is the most problematic because in spite of the safeguard saying that there should be no trafficking of human beings, we see in the Indian society trafficking is a huge problem, is a huge social problem, and it has not been able to be solved over the years that the constitution has been effective. If we look into the laws under the Indian Penal Code, that is the IPC, it is an effort to uphold the constitutional mandate of gender inequality. That large number of legislations were enacted by the state and the national government to ensure that the women are guaranteed equal right over in the matters. And in this we see that these are crimes which are directly, specifically against women, and these are described as crime against women. These are broadly classified into two categories. The crime identified under IPC are rape, that is section 376 of IPC, kidnapping and abduction for different purpose, that is section 363 and 373 of IPC, homicide for dowry, dowry death or the attempt, torture, both mental and physical, molestation, sexual harassment, importation of girls. These are all which are described under the IPC as crime against women, and they are legal measures to give punishment, and many of the time the punishments could be life imprisonment or even death penalty, because these are considered as a crime under IPC. And then we also have crimes under special law, that is special laws have been made for the protection of women's dignity and her right. And these laws are basically laws related to marriage, law related to property. There is a large list of laws which is actually very problematic to go through in a very short time. But let us just go through the main laws which would directly affect women and the functioning of these laws. We see the Hindu Widow Remarriage Act of 1865, where widows were allowed in a society in the 19th century. Widows were not allowed to marry, and these were all the task of reformers to bring about Hindu Remarriage Act of 1865. Then we have Brahmo Samaj Marriage Act of 1872, which is the forerunner of the Special Marriage Act. And then again we have this serious debate on Uniform Civil Code. Uniform Civil Code means a uniform personal law on such matters as marriage, divorce, maintenance, adoption, guardianship and succession, regardless of one religion. In the part 1 of the lecture, I said that laws intersect with community rights, and in the Indian context we see a large number of time the gender or the women's status is considered as subordinate to the status of the community and the status of the religion. That is, each religion, Hindu, Muslims, Christians, have this separate law, which actually becomes problematic in terms of guaranteeing women her status. And there was a demand for uniform civil code, but in spite of the struggle by women's movement, the uniform civil code is still debatable in the Indian context. Then we see the Women and Property Law. For the Hindu Succession Act 1956, it applies to Hindus, Buddhists, Sikhs and Jains. Before the act came into force, a Hindu woman did not have absolute control over her property. She had only limited estate. Once he died, it went back to the reversioner and not to her heirs. That is, it was only under the Mitakshara law, the women were denied any kind of access to property. The Hindu Succession Act came into force on June 17, 1956 with a view of conferring absolute ownership of Hindu female in the property which was in her possession. There were a large number of amendments in the property law. In September 2005, the Hindu Succession Act was amendment, and it gave daughters in a joint Hindu family governed by Mitakshara law right to property. That is, she could be a part of the property which was owned by her father as a co-partnership. However, in 2015, the Supreme Court ruling restricted the right of the women seeking equal share in ancestral property, because the 2005 amendment gave right to women, and the 2015 judgment said that it could not be applied retrospectively. That is, the father of the daughter had to be alive when the judgment was passed in order to daughters to have access to the property. Now, what is important to understand the linkage between gender and law is that it is not having a law. What is important is to see that the law actually functions. And in the property is the most, because it is a question of legal right versus relations. And in a society where family is a significant institution, where family relations are very important, it is very difficult to go to the court to take legal rights. And therefore, if we give a small example of what would happen in a state like Punjab, which is a well-to-do economic landed property, and it is a question of joint family, the daughters themselves don't deny right to property, because the property is related to the part of the dowry and the customary relations, where daughters are part of gifts and take in and take out. So if you ask for legal rights, implies that the relation gets affected. So the sibling relation is important to maintain rather than claim legal rights, and therefore daughters in Punjab would not claim property rights and would, in order to maintain the solidarity between brothers and sisters. And this is very important to understand, that how can law be used in order to actually guarantee equal rights to women. The dowry prohibition, dowry is again a very problematic question when it comes to India, because if we see that the prohibition was passed in 1961 and there has been several amendments to the Dowry Prohibition Act. But in spite of the Dowry Prohibition Act, whereby the amendment said that both the takers and the givers would be considered as crime. And dowry is not only a gift given at the time of marriage, it is a regular gift of marriage. And that is why in India, where customary practice are so strong, and these customary practices has been designed keeping in the patriarchal structure. So daughters who visit their home cannot go empty hand, and therefore a large amount of gifts has to be given to them. The first child is born to the couple, it is the gift that comes in from the bride's side. So it is not only that give and take of money at the time of marriage, but it is, since the negotiation of marriage starts till the death of the daughter, the continuous giving of gift from the bride to the groom is problematic, and that is why dowry has become problematic. The other area where dowry has become problematic is to see in terms of these heavy fat weddings, or you see that where weddings have become a status symbol. You need to have a very lavish wedding to show off your status, and most of the time the cost of the wedding arrangement is on the bride family. Now this does not get considered as a part of a dowry prohibition, because neither the bride family nor the groom family nor the relatives nor the friends would go up and say that we do not need a lavish wedding and it is considered as a dowry. And what is problematic is those who can afford, it's fine, but the status acquisition or the desire to have a wedding which is a kind of a show off triggers from the upper well-to-do family to the lower class family, where the lower class, a father from a lower class would have to take recourse to debts, would have to sell off his property, would have to go into some kind of economic crisis to ensure that the same status of a very heavy, very expensive marriage is done, and that becomes problematic. Then we have a very landmark law in the Indian context, which is the Protection of Women from Domestic Violence Act 2005. This is a civil law which is protecting the rights of the married daughters in the country, and it gives them the right to stay in the shared property of the husband and protect the women from any kind of violence. It is the first law in India to define domestic violence in a comprehensive way, because for a very long time violence was considered as a private matter, that it is taken within the four walls of the family, and therefore it is something that needs to be negotiated inside the family. It was again structured by the patriarchal system, where the conjugal relation between the husband and a wife is seen as a relation between dominant and subordinate. And again, the whole understanding of the Hindu marriage in the Indian Hindu society, where marriage is kind of a sacrament. It has a religious base. So it was not surprising to hear a large number of police officers saying that there is no problem if your husband slaps you once in a while. So the whole understanding of violence that was taking place within the realm of the house to consider it as a crime was problematic. And that is very paradoxical, is that if someone slaps a person on the road, it becomes a crime. But if it is within the four walls of the house, it was not considered as a crime. So the domestic violence law was a landmark judgment in terms of protecting women within the four walls of the house, and it gave them, the government, the responsibility to ensure that the violence inside the house is prevented, and therefore it is a right of women to have access to the share of the house, because a large part of the violence victims, if you listen to their stories, it would be that there would be a fight in the house, and the husband would throw the women out of the house in the darkness of night, and she had no place to go. So prevent this to happening, the law gave the women right to residence and gave measures or gave protective orders to the family of the victim to stop any kind of violence on the women, and this became a significant part of the law. If we look into the milestones which has been achieved by the Indian legal system, we see that the first revision in rape law took almost around a long period of time. It was revised in 1983. Initially, it was the burden of proof was on the accused, that is that the victim who was raped had to prove her innocent, and it was not the one who was committing the crime. Till the amendment came in 1983, it was problematic, and large number of Bollywood movies have shown how the women became a portrayer of culture, her identity, her sexual habit, her manners, her virginity all became a part of demonstration in the court, and that prevented victims for accessing law. So the amendment became significant, where it was not the onus of proving yourself innocent passed from the victim to the culprit. And the minimum punishment for rape increased from 7 years to 10 years. 1994, prohibition of sex selection. Now, we know in India we have a whole idea of the desire for son, and even the sex ratio in our country is badly affected, where in states like Haryana and UP, we have the sex ratio going down to 1970s in the last census. So by 94, we had a law which was prohibiting sex selection. 2003, the cross-examination of victim of assault was not allowed, and the beginning of the camera proceeding began in that it was not necessarily for the victim of rape to give her understanding that she has been raped in front of the other members of the society. 2004 Hindu Succession Amendment Bill was passed, in which the law of inheritance was changed and they gave right to property to the daughters. A large number of laws were passed. In 2006, Sexual Assault Bill was passed, where the sexual harassment law became significant, where it tried to protect the women from any kind of harassment at the workplace. 2013, the Criminal Law Amendment Act, and that is the criminal law was amendment, and this is after the famous Delhi gang rape, where it was trying to change the way in which the criminal proceedings took place, and that was one of the intention of bringing about this amendment is that larger number of women are able to use the law, and the law is able to be utilized in a more gender justice manner, so that more and more women can take recourse to it. 2015, right of guardian to unwed mother by Supreme Court, and that is that is again a protection given. For a very long time. The Guardian Act was such that it only recognized the male or the father. So many a time if the father's name was not on the any form, it would have been rejected. If you applied for a kind of a passport and the father's name was absent there, it would have not been guaranteed. It took a long struggle for the women's movement to ensure that the Guardianship Act changes and single women were given right to have custody of the unwed children born. If we look into the campaigns that has been a part of the Indian society, the women's movement has been engaged with the laws from the initial, because as we have already seen that the law was a site for struggle. So the agitation against rape laws, and there was a large number of changes in rape law, campaign against dowry, and which brought about the Dowry Amendment Act, anti-sati agitation. 1987, Roop Kanwar was a young girl who was wedded to an aged man, and she was forced to commit sati, and there was an agitation against it. But this case is again a case where we see women's legal status gets intertwined by community and culture, and there is large number of Hindu conservatives who would argue that sati is right. There are organizations in parts of Rajasthan that advocates the practice of sati. So the legal status or the identity of a woman gets subversive to the identity of community and culture, and that could be a large number of women would support the whole idea of sati as a practice rather than rejecting it. Then we have the support for uniform civil code from the Sabano case. The Sabano was a 72-year-old woman who, being divorced by her husband, asked for maintenance, and the court guaranteed her the right to maintenance. But there was a lot of agitation from the Muslim community, and Muslim community being a minority community, they said that it was the society intruding upon their right, and therefore from the pressure from the community, Sabano had to withdraw her case. Since the time of Sabano's case, there has been a campaign for uniform civil code by the women's movement. Then we have campaigns on law on marital rape, where large number of many countries consider marital rape as a crime, but in India, where marriage itself is a sacrament, and it is not a contract, unlike in the Western countries, and where marriage gives the right of women's body over men, marital rape is not considered as a crime against women in India. If we look into the landmark judgments, we see the Supreme Court in Mutamma versus Union of India and Air India versus Narges Mirza struck down discriminatory service condition requiring female employees to obtain government permission before marriage and denying married and pregnant women the right to be employed. In Vishakha versus State of Rajasthan, the Supreme Court observed that equality in employment can be seriously impaired when women are subjected to gender-specific violence, such as sexual harassment in the workplace. This is the Vishakha judgment is the landmark judgment in the sense the sexual harassment at workplace bill got ratified after the case. And today women are protected against sexual harassment at the workplace. In Mackinnon, Mackenzie and Co. Limited versus Audrey D. Costa, the court observed that there are discrimination in payment of wages to lady stenographer, and such discrimination was being perpetuated under the garb of a settlement between employees and the employer. The court finally not only made it mandatory to pay equal remuneration to lady stenographer as their male counterpart, but also observe that the ground of financial incapability of management cannot be a ground to seek exemption from Equal Remuneration Act 1976. The National Legal Service Authority versus Union of India 2014, the judgment provided legal recognition to third gender apart from male and female, and this is again considered as a significant judgment because now we see third gender coming out and becoming a part of the society. The Delhi High Court had ruled that the eldest female member of the family can be a karta. So for a very long, the karta was legal heir of the family who had the right to perform the last rites of the family. But in families where there is no male members and the female is the eldest member, the court has guaranteed them the right to become karta and perform the last rituals of the parents. The Supreme Court has given a landmark judgment in terms of the live-in relationship, which is, it has recognized the live-in relationship and has given the right to children born out of such relation as having all the rights of a biological child. Then there was a PIL filed to examine the discrimination suffered by women under Islamic law, Article 14, 15 and 21 of the Constitution, and they gave them the right to do away with this discrimination against women. But in spite of these landmark judgments, they have been judiciary bias. Here the judiciary bias implies that there have been judgment which has been colored by patriarchal understanding of the judges. In the Mathura rape case, where the Mathura was a girl who was raped in the police custody, it was the judgment which gave in was that you need to have physical marks on your body to show that you have been a victim of sexual harassment. The judge gave a comment where there was absence of any physical violence and gave a judgment that it could not be a case of sexual violence on the women, rather it was a consent. So it was again the character of the women which was brought into picture in order to understand the judgment. Again the judgment given was Mathura is habituated to sex, must have been given consent. The second was Ramija B is a prostitute. Ramija B was coming back from a night show movie with her husband who was a rickshaw puller, and he went out for a call of nature. Otherwise, he was all alone. The two police constables took hold of her, considering that she is a sex worker, took her to the police custody, did sexual assault and left her. When there was a complaint against it, her husband was badly beaten by the police and he died. And then the judge passed a comment that she was a prostitute because she was out in the night all alone, without going into the details. Then there was a Bhamri Devi rape case where Bhamri Devi was one of the social workers where she was protesting against child marriage, and she was raped by a group of society custodians. And because these men were from the upper caste, the judge said that the upper caste men cannot rape a lower caste women, and on that ground they were left. So these judgments are problematic because it clearly indicates that it is colored by the patriarchal mindset of the judges. Though each of these cases are significant because they have been taken up by the women's movement and there's a lot of legal campaign against them, and these judgments have gone up for revision and they have led into large number of amendments in these laws. But what is important is to understand that the judgment is not necessarily based on the laws, the way the laws are written, but it is again the mindset which is going to give the judgment pro or anti women. And that is to bring to an end of the struggle, to bring an end to the lecture. We see that there is a long struggle that needs to be done because the rate of conviction is very low, and we've seen that the crime against women rather has been increasing over the years. There are large number of debates which are going on. Why is there an increase in crime against women? What is the legal judiciary doing in terms to control crime against women? The judiciary is corrupt, so only 5% of the guilty are punished. In the PCPNDT Act, it is very few people who have been actually punished by the law, and sex selection is still a practice in every part of the country, because the sex ratio which was high in states like Kashmir has also dipped down. In Delhi, which is considered to be an urban elite society, the sex ratio is again problematic, and it is the west part which is doing a large part of these selections. So it is very important to try to understand the law can be used as a weapon for bringing about gender justice in the society. Thank you for this lecture.
Thank you, ma'am. Thank you so very much. And dear friends, if you have liked the lecture, or if you want to give your feedback or want to have answer of any of the questions, then you can mail us at info.cc@nic.in. We would be meeting again very soon and would be discussing on another topic under the series, gender studies. Till then, take care. Goodbye. Thank you, ma'am. Thank you so very much.